Good evening. Happy Wednesday. I tried going through this video and I am having a hell of a time. I thought this was going to be a 10-minute video on why we have to get cameras into the courtroom by Chillie Decastro, Jose Maria Chillie Decastro. And I swear to God, this guy's like a meth head. He's hard to follow. And I got lost and I'm starting over again, and I apologize about that. You could buy this particular picture. This is a picture that he sells on his website for $25, or the laminate version for up to $140. I don't know why you would buy this. This is titled The Unedited History of the United States of America. It is obviously edited. The very fact that it is contained on a single poster makes it patently obvious that it is edited. It does not contain every single bit of history of the United States of America. It contains the bits that Chillie, in his naivete, think are important. For example, under the Bill of Rights, just this basic stuff, he has the Fifth Amendment as the right to remain silent. The Fifth Amendment encompasses way more than the right to remain silent. He has the Sixth Amendment as the right to face your accuser. The Sixth Amendment encompasses way more than the right to face your accuser. He has the First Amendment as liberty. That's it. Liberty, period. End of story. Done. This is just stupid. This is just stupid.
This is the reason why we have to get cameras in the courtroom. This is the poster, the digital poster or the printed poster.
Just so you're aware, expect this a lot throughout here. He starts off, this is the reason why we need to get cameras in the courtroom. This is a poster. Like, you just were about to tell me why we need cameras in the courtroom, and then you get completely sidetracked and you want to start telling me about your poster that your mom put up on the refrigerator and you're so proud of, and you want to show off to all your friends about this poster that you made. Like you're a fifth grader.
That I put out in July of 2021. And what I want to focus on here is, these are a bunch of Supreme Court cases that if you know them, it'll help you a whole bunch and understand.
So these are not all Supreme Court cases. Obviously, the 1937 Marijuana Tax Act is not a Supreme Court case. The Model Penal Code is not a Supreme Court case. The Model Penal Code isn't even law. It's not even law. The Model Penal Code is not law. It is something that a group of lawyers and judges came up with as what they believe the model, the best possible example of a penal code should be. And some states have enacted portions of the Model Penal Code into their statutes, but no state, to the best of my knowledge, has enacted the entire Model Penal Code. And the Marijuana Tax Act obviously is an act. You don't need to know all of these cases. These are some pretty stupid cases. Plessy versus Ferguson was the separate but equal, overturned. Bad Elk versus United States, has been overturned basically because we don't have common law in Indian Territory anymore. There's a Code of Federal Regulations that states what the basic penal codes are in Indian Territory, or a tribe can enact its own. So Bad Elk is bad law. Buck versus Bell was partially overturned. Korematsu versus U.S. in Trump versus Hawaii, or Hawaii versus Trump, I forget which way it goes. But the court there said that they essentially said it was disproved, like it would no longer be like, basically they said it was wrongly decided. That's what I want to say. It was wrongly decided. So, I mean, if we ever get invaded by Japan again and try to inter Japanese citizens, and a state relies, or the government relies on Korematsu for that particular act, then the court will strike it down. So these are not all cases that you need to know. And in fact, many of them are no longer good law, period.
Understanding how the Supreme Court works. That's one.
None of this says how the Supreme Court works.
Thing. This is the lynching graph here, and then
lynching graph. Like, lynchings aren't super common anymore, son. We're kind of done with that.
Here's the United States, and
Here's the United States. Look, Ma, I put a picture of the United States in here. So this, in Chillie's view, is the United States. And there's only two things of import in the entire United States, and that's the St. Parish Massacre and the Colfax Massacre. Wow. And, oh, look, white lynchings versus black lynchings. I just noticed it says there's white and black lynchings. Looks like...
this is the lynch.
Looks like there's a lot of white lynchings there. Huh.
Lynching graph here, and then here's the United States, and then your...
Look at how far down these white lynchings go.
Fourth Amendment is down here. The Fourth Amendment is the right...
The Fourth Amendment is down here, along with Chillie's PayPal, his Cash App, his Venmo.
...of the people to be secure in their person, houses, papers, and effects against unreasonable searches and seizures shall not be violated. And no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized.
So you could pay $25 to have basically a weirdly spaced and written out sample of the Fourth Amendment. Congratulations. And Chillie can read. Yay.
This line right here, this white line that starts back here, this is the prison population graph. And if you take a look at the prison population graph, right there, that spike right here, this is over prohibition right here. That's what you're looking at right there. See if I can... grab a pen so I can pop my pin in here. This right here, the reason why we have a prison industrial complex, just so you know, is because this aligns with Prohibition 1920.
So he's got that spike aligning with Prohibition from he said about 1920 to about 1933, right? 1920, 1933. Well, this is from Wikipedia, as you saw me type it in there. There's 1920 to 1933. There is not a huge spike. This is 500,000 right here. So it looks like we hit 500,000 right around 1978. I don't know where we are on his little weird-ass graph. But there's not this huge spike from 40-ish thousand to 200,000 between 1920 and 1933. It looks like it's about, if you divide that by fifths, 1, 2, 3, 1, 2, 3, 4, 5. It looks like that's 150 to 200,000 is where it starts. And by 1930, it looks like it's about maybe 200 to 250,000. So I don't believe that his chart here is accurate.
Because this aligns with Prohibition 1920, 1933. This is the first building of Prohibition.
I mean, in addition, it's a post hoc ergo propter hoc. I mean, what else was going on in 1920? I mean, let's just assume, arguendo, that his graph is accurate and to scale and all that other fun stuff. Let's just assume that. What else is going on in 1920? Well, troops were getting home from World War I with shell shock and things like that. I mean, we sent over a bunch of boys to fight over there in the fields of France and Germany, and that's the introduction of trench warfare and shelling, and that's where shell shock came from. I mean, that's where we learned about shell shock. So we didn't have a lot of support for PTSD back then. We didn't have Zoloft and all the other drugs. So, I mean, it's post hoc ergo propter hoc. We don't know exactly what the cause of that was. It could have just been an increase in population. I mean, there might have just been a spike in population between 1920 and 1933, like with people fleeing Depression era Germany. Germany was the Weimar Republic, with lots of bad stuff was going on. Might have had a huge influx of Germans over that time. Who knows? Who knows what's going on? Who knows what would have caused it?
Prohibition of the prison.
That's the problem. Like, these numbers can be misleading. What we should be looking at is like percentage of the population in prison. And maybe there's something like that on Wikipedia. $1925. So it starts off a little bit, but the incarceration rate of inmates under state federal jurisdiction per 1,000 population. So incarceration rate per 1,000 population. So there was like 100. So the graph did grow a little bit towards the late 30s, and there was a spike from 25 to 31-ish before it leveled off. So what was going on in that range that led to the well, it was Bonnie and Clyde back then. And yeah, Prohibition did lead to the rise of the mobsters. So maybe it did have something to do with it. I don't particularly know. But his initial chart, his chart does not look like Wikipedia's anyway.
Industrial complex.
And I'm not sure that there was a prison industrial complex back then. Nowadays, there's a prison industrial complex because instead of actually housing inmates itself, the federal government and state governments like to pay private companies to house their inmates. So there's a booming economy around housing inmates. And I think there have been some judges that have been disbarred and disrobed from having like basically deals with prisons where they send inmates to prison, or they send people to prison. They give people prison time just to make sure that particular prison gets enough new inmates.
We're going to go from roughly 30, 40,000 people in prison to 200,000 people in prison by the time Prohibition ends. And then it's going to keep going right here. And
so the weird thing here is when Prohibition ends, you would think that line would go back down, but it doesn't. So was it Prohibition? Was it not? I don't know. I thought we were going to talk about getting cameras in courtrooms, but I guess that's not what we're dealing with.
This giant spike right here, you guessed it, come all the way up. It's Terry versus Ohio.
You guessed it. Terry versus Ohio caused a giant spike in prison rates. Well, I thought it was going to be cameras in courtroom that we're going to be talking about, but I don't see a giant spike in prison rates or in incarcerated Americans in 1968. I see it start to spike around looks like the mid-70s. So, I don't know.
I always talk about Terry.
But again, what does this have to do with cameras in courtrooms?
These Supreme Court cases you should definitely know, but let's talk about something.
These random Supreme Court cases you should definitely know.
Important.
Why should you know them? Just out of curiosity, why should you know them? You go to a law library and look up a criminal practice guide, like a criminal practice before trial. Like the Rudder Group might have a criminal practice before trial for like just about anything. Like they have I know they have a drunk driving one because we have a copy of that in the law office, one of the law offices I work at. And go through it. See how many of those Supreme Court cases they discuss in that drunk driving practice guide.
From 1968, and
you would think if it was important, if those Supreme Court cases were important, they would be referenced ad infinitum in these practice guides, because these are literally what lawyers use to try to get their clients found not guilty. Like these are defense guides. These are the motions you could make to suppress evidence. This is when you make them. This is how you make them. And you'd think that if these were really important, they'd be in all these practice guides. But I challenge you, go to your local law library. Go look up these practice guides. See how many times these Supreme Court cases that he is saying you need to know, see how many times they're referenced.
The war on drugs with Nixon in 1971, you create this massive prison system that goes up 100,000. Each one of these thin lines is 100,000 people.
Drugs were criminalized well before 1971. Well before.
So what's the big problem we have here?
Well, I'm going to guess the big problem we have in here is we don't have enough cameras in courtrooms. Or it could be the 1971 war on drugs, which you claims caused a massive spike. You just said that was what caused a massive spike. Or it could be prohibition, which you said caused the military industrial, or not military industrial, the prison industrial, whatever. So, I mean, what is it? Like, you're all over the place. What is the cause? Can we get to cameras in the courtroom, please?
Is that there's no audio and there's no video in the courtroom. If you're getting such a fair deal in court, then how come our prison system has taken off like this since 1968?
Well, you just said that Terry versus Ohio was the reason for it. And now you're saying, oh, but the reason is actually cameras in the courtroom. Like, get your story straight. Like, what is it? Is it prohibition? Is it the 1971 war on drugs? Is it 1968 Terry versus Ohio? Is it cameras? Which one is it? Which one is it?
Right there. Well, we know that 71 is the war on drugs, but Terry versus Ohio that allows cops to run up and just put their hands on you and grab you, that's the real problem. It puts officers...
It allows them to detain you if they have reasonable suspicion that crime is afoot. It allows them to frisk you if they have reasonable suspicion that crime is afoot and that you're armed.
Safety over your rights, and that's why cops can grab you. Now, you have a bunch of information on here, like the 1970 Substance Control Act, which is pretty much going to be completely written by one man. It's going to be written by this guy right here, Frenchie. Frenchie is going to be...
The 1970 Controlled Substance Act was written by Congress. It went through multiple committees in the House and the Senate. Multiple congressmen and senators had input into the 1970 Controlled Substances Act. It wasn't written by one guy, and it certainly wasn't written by Reagan's Secretary of State, because Reagan was governor of California in 1970. Yeah, it was 1970, 6-year term, blah, blah, blah. Yeah, 1970 he was governor of the United States. Or no, governor of California. He became president in 81.
Reagan's Secretary of State, and this guy's going to write all the...
And secretaries of state, they don't write legislation, so no on that.
All the laws that are going to uphold the 1970 Controlled Substance Act, including...
What do you mean laws that uphold it? Like, the 1970 Controlled Substance Act is a law. So I don't know what you're talking about there.
A civil asset forfeiture that's going to be led by Joe Biden when he's in the Senate.
So now we're talking about civil asset forfeiture. Federal civil asset forfeiture started sometime around... That was under Reagan. That was 80... I'm going to say 85, 86, somewhere in there. Late. It was the second term. One of the many shitty things that he signed into law. But yeah, it wasn't his Secretary of State having anything to do with it. That was, again, Congress, the House and the Senate, writing a bill that gets passed by Congress and gets sent to the president, who then signs it into a law. I mean, there's a Schoolhouse Rock video on it. Maybe you should watch it.
And so you get the 94 crime bill that's going to capitalize.
So now we're on the 94 crime bill that's going to capitalize on the 1970. Like, what the fuck are you talking about, dude? Like, you just like throwing things out there. It's just word salad with, oh, this happened and this happened. Look at this poster that I'm trying to sell for $25 a pop. See how you need it? Because I can point to things on it that don't mean anything. The COPS program. Oh, the 1972 Knapp Commission. What does that even mean? What does that even mean? What does that even effing mean?
On the 1970 Substance Control Act, and then cops can run up and grab you if they're suspicious of you. Well,
if they have reasonable suspicion and they could articulate facts, it would lead a reasonable person to believe that crime is afoot.
Half of our country has some kind of chemical that they do, from coffee to heroin and everything.
Last time I checked, coffee was not illegal. Whoop, I hit a button. Didn't mean to hit a button.
In between, from marijuana to alcohol, you name it. And
And, you know, a lot of states have legalized marijuana, so at least the state isn't prosecuting you for the possession of marijuana in a lot of cases, sometimes even the manufacture and distribution of it. So, you know, you should see your little graph has crime going up and up and up, but you should see a drop off. You should see a drop off like that right there.
So the reason why I put the secretaries of state on this particular graphic,
The reason why you put secretaries of state on the graphic is because you're a freaking idiot.
is because I wanted people to realize that it's not the president necessarily all the time who does it.
Who does what? Who does what? Who signs bills into law? Who prevents you from carrying cameras in the courtroom? Who incarcerates people? Like what, dude? Who does what?
It's also the secretary of the state, like Frenchie. But
Who's this Frenchie Secretary of State? I don't know if any. Reagan's Secretary of State was not Frenchie. Reagan's Secretary of State was Schultz, not Frenchie. I don't know. Is this guy called Frenchie? There is no Frenchie, so I don't know what the hell you're talking about. By the way, if you hear Cheapers, Cheapers was born on Sunday, and we're not assuming Cheapers' gender. We don't actually know Cheapers' gender at this point. But Cheapers is a lonely chick right now waiting for his or her brothers and or sisters and or non-binary others to hatch.
this, just so you know, the 1970 Substance Control Act, this was written by a guy named John Mitchell.
I thought you just said the 1970 Controlled Substances Act was written by somebody named Frenchie. I don't even know. Now it's written by a guy named John Mitchell. No, it was still written by Congress. It was still written by Congress. The 1970 Controlled Substances Act. 1970 Controlled Substances Act. Announced Attorney General John Mitchell was preparing a comprehensive new measure to effectively meet the narcotic and dangerous drug problems at federal level by combining all existing drug laws into a single new statute. With the help of White House counsel head John Dean, the executive director of Schaefer Commission, blah, 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 created John Ingersoll creating and writing the legislation, was able to present Nixon with the bill. The CSA not only combined federal drug The CSA not only combined existing federal drug laws and expanded the scope, but also changed the nature of the federal drug law policies and expanded federal law enforcement pertaining to controlled substances. Okay. I don't know about that. It was introduced in the House by Harley Orrin Staggers Sr. It went through the Interstate and Foreign Commerce Committee and the Senate Judiciary Committee. It passed the House on September 24th. It passed the Senate on October 7th, both of 1970. And it was reported by the Joint Conference Committee, and it was agreed to by the House and the Senate. So then apparently everything was like adjusted so that they both met their needs. Major amendments was in 2000. Okay. So I guess it wasn't Frenchie. It was written at least predominantly by John Mitchell, his Attorney General, and not Secretary of State. Okay. But again, it did go through Congress, and Congress would have amended it, changed things, etc. They always do.
John Mitchell's right there. John Mitchell's underneath of the timeline. You can barely see his face. But John Mitchell was the Secretary of State for Richard Nixon, the Attorney General. I'm sorry, the attorney, not the Secretary of State, the Attorney General.
Okay.
This guy's an Attorney General as well. John Ashcroft, an Attorney General. You guys know who these guys' Attorney Generals are: Barr, Sessions, all these guys, and these two guys are cops.
Wow, I mean, cool poster, dude. Look, there's cops on here. Wow, wow.
But I'm showing you guys something, Roberto Gonzalez, right here.
I must be taking crazy pills. I swear to God, I thought this video was going to be about why we have to get cameras in courtrooms. So far, you've stated it twice, but you haven't presented anything as to why we need cameras in courtrooms.
I'm showing you something important here. When Nixon creates the war on drugs, in 1970, John Mitchell writes the 1970 Controlled Substance Act on his own. He sits down and writes it by himself with a couple of paralegals.
White House counsel head is an actual attorney. John Dean was an attorney. Michael Sonnenrich was an attorney. So paralegals, no. You're the one who uses paralegals, Chillie.
And the 1970 Controlled Substance Act is the entire basis for the 1971 war on drugs.
Well, again, but take a look at this. It combined all existing federal laws on drugs into a new statute. It added some, but there already were some in place.
So now cops can run up and grab you in 1968 because Terry versus Ohio.
With reasonable suspicion supported by articulable facts.
They can jerk you out of the car from the 1977 case of Pennsylvania versus Mim.
Pennsylvania versus Mims. That was the one where you can get the driver out, right? What was the other one where you can get the passenger out?
The 76 case of South Dakota versus Opperman says they can impound your car if they're suspicious or they need to inventory your car.
If they're suspicious or they need to inventory your car. I don't think so. Opperman. If I'm not mistaken, that's where a Opperman one. That's where a off-duty police officer was passed out and they impounded his vehicle. So it was, okay, so it's not the one I thought it was. All right, so there was a vehicle that got parking tickets, okay, and he observed a watch. So then it was impounded. So it was parked illegally. They put 2 tickets on it. And then it was impounded. So this is the inventory search. So yeah, when they impound your car, they can inventory search it. But it's not just when they're suspicious of it. It's they can impound your car if they impound your car. If they can impound your car, i.e., like if you're drunk driving and they arrest you, they will impound your car, and then they will search it. They will do an inventory search because it's now in their possession, and they have to protect themselves and you. So they have to be like, oh, I don't know if there's. Well, that's the reasoning anyway. I personally think they should have to get a warrant, but whatever. But the rationale of the court is that it's to protect them and you. So like if you have something expensive in there, the police know it, and they inventory it to make sure that you get it back when you get your car back or whatever. I disagree with the rationale of the court, but that's their rationale. It's to protect the cops, it's to protect you. I think they should have to get a warrant, but I'm dumb that way. That's not what the court says. But it's certainly not just they can just go ahead and impound your car whenever, and they can search it just because they're suspicious. No, they have to have a reason, a valid reason to impound your car.
So you don't have a chance when you get in your car. And this goes back to the 1925 case of Carroll versus the United States.
Carroll versus the United States was you don't have to get a warrant to search a vehicle unless circumstances are such that you can get a warrant, and that's because vehicles can be moved so quickly and easily. But the search still has to be based on probable cause.
If you know all the cases on this graphic, if you know all of them, if you know what the model penal code was and why it was written, from 1952 to 1962, it's going to be written by a guy named Wexler and a guy named Harry Blackman. I don't think I have him pictured on here. But the point is when we can't get our cameras in the courtroom...
Wait. If you know about all these cases, you know why the model penal code was written. But the point is, like, dude, you haven't said any particular reason why we need cameras in the courtroom yet.
When you can't get your audio video in the courtroom, this is the outstanding result.
I thought that was the outstanding result of Prohibition, of the 1971 War on Drugs, of Terry versus Ohio. I'm sure there's other things that I've missed by this point. Of the 1994 crime bill. I mean, I thought those were the reasons for it.
You have all of these millions of people living in a dungeon.
Look at this graphic of a person I put on there. You need to buy my poster.
Everything the government does is to put you in a dungeon.
That's a little bit of hyperbole. And not everything the government does is to put you into a dungeon. A lot of things they do are to make you into a wage slave and a tax payer, or dependent on the government, one of the two. Either paying taxes or depending on the government for your benefits.
There's very few remedies for anything that they consider a crime against you. You will be put into a dungeon.
Not necessarily. You won't necessarily be put into a dungeon. I mean, they dismiss a lot of cases that they could otherwise win simply because they don't want to prosecute. There's DAs who run on their promise that they're not going to prosecute certain low-level misdemeanors. There's deferred adjudication where instead of actually getting sentenced, you do something or you stay clean for a period of time and the case against you is dismissed without ever rendering a not guilty plea or a guilty plea or a nolo contender or a guilty verdict or anything like that. So there's not only those, but there's also probation, deferred or delayed sentencing, things like that. There's pretrial diversion, and then there's also delayed sentencing, which means that anyway, there's lots of things that they do. Sometimes they'll just fine you instead of making you go to jail. Anyway, there's lots of things they do that don't end up with you sitting in a dungeon.
And nothing hurts us more today than the 1994 crime bill. But
I don't know about that. 1994 crime bill. Load. That's not what I want. I want Wikipedia. Load. So the federal assault weapons ban expired in 2004. The Federal Death Penalty Act was declared unconstitutional. The elimination of higher education for inmates. might still be around. The Violence Against Women Act, part of that was declared unconstitutional. The driver's privacy. Anyway, you can see that the 1994 crime bill has been substantially defanged over the years. So I don't know if it's like what did he say? Nothing hurts us more today than the 1994 crime bill. I don't think so.
The 94 crime bill works in conjunction with the 1970 Controlled Substance Act, which works in the conjunction with the 1971 War on Drugs, which then...
The 1971 War on Drugs was basically what they call the results of the 1970 Controlled Substances Act. So works in conjunction. These are just words that you're like, bleh. Like, I don't understand. I just don't understand.
Then Frenchie and Reagan are going to create civil asset forfeiture, and that's going to go through the legislature, but that's going to be pushed through by Joe Biden.
Frenchie and Reagan. I know civil asset forfeiture was under Reagan. Who is Reagan's attorney general? Ed Meese? William French Smith. So this would be the Frenchie he's talking about. William French Smith. Let's see if there's civil asset forfeiture. No civil asset forfeiture. I think civil asset forfeiture is like in 86. 86. Did this dude do it? Civil asset forfeiture. Uh, 18 USC 450. It's 922. Civil forfeiture proceedings. When were you enacted? 81, civil forfeiture. 86. I was right. And you're not going to give me what I want, are you? Are you going to give me? No, you're not. You're not. Ooh, you are. You are. Load. Load. No results. How much you load? Yay! Download. Downloading. Download. I'm on country internet. This is what you expect from country internet. Downloading. We are still downloading. It's like back in the 80s waiting for porn to load, right? Get that JPEG. There we go. All right. Yeah, so Congress... Congressional record. September, it was considered... Yeah, so this went through in 86 after Frenchie was out. So I'm not saying Frenchie, as he likes to call him. Where are we at? Where are we at? whatever the dude's name was. Maybe you? Are you? Could you be? Nope. Could you be? Nope. Anyway, whatever that guy, I don't know if that guy was passed it or not, but who wrote it or not, it did make it into his Wikipedia page. It went through, you saw, it went through, it was considered and passed the House, considered passed the Senate as amended. The House concurred with an amendment. The Senate concurred with amendments. And then the House concurred with amendments. And the Senate, with amendments. So it got amended a lot. So one dude did not write it.
Joe Biden creates that, and then Bill Clinton signs the 1994 crime bill, which includes the COPS program and Operation Relentless Pursuit.
Yay.
And just so you know, the 94 crime bill, it's just an extension of the 1968 omnibus crime bill, where they introduced gun control.
Gun control is older than 1968. Oh God, what was that one? They banned sawed-off shotguns and semi-automatic weapons back in the 30s, I think. Supreme Court gun control 1939. Miller. Load. View case. Load. The National Firearms Act. They were talking about the National Firearms Act in 1939.
Now, gun control still goes all the way back to the 1911 Sullivan Act, which is going to be right over... Where is it? So sorry, I'm
1911 Standard Oil breakup. No Sullivan Act. Huh. I guess your stupid poster thingy doesn't have everything you wanted on it.
I'm a little lost here. I'm trying to find it. The 1911 Sullivan Act,
right there.
Right there. So the 1911 Sullivan Act is what is where the 1968 gun control legislation comes from.
That's kind of weird saying that it's where it comes from. I mean, the Congress decided that there was a problem that they could fix that wasn't addressed in a prior statute. I don't know if I wouldn't say it comes from that.
You have that 1968 omnibus crime bill, but that's created from the 1911 Sullivan Act. People don't know that the 1911 Sullivan Act is still the legislation in most states today.
It's still the legislation in most states. Well, if it's federal, it's in all states? Because it's federal. States have their own legislation. So I don't know what the hell you're talking about. Let's look up the 1911 Sullivan Act, I guess. That's New York. New York passed it. So it's relevant in New York. It's a New York law. It's a gun control law from New York State.
Now, there's some states that are doing constitutional carry and things like that, but you shouldn't have to get a gun permit or a gun license or anything else.
I agree with you.
All of these different things are working together.
But that's not what the Supreme Court said.
I just want to go back to it, though. Unless we have audio, video in the courtroom, then they're altering the record. You're not getting...
Where have you proven they're altering the record? Where have you shown anything about altering the record? Where have you shown anything about altering the record?
Unless we have audio, video in the courtroom, then they're altering the record. You're not getting the record.
What do you mean you're not getting the record? You could order a transcript. If there's a court reporter there, the court reporter's taking out everything that's said verbatim, and you can get a copy of the transcript. That's the record. That is the record.
Can't audio record your hearing. Why? Who are they protecting from your audio recording? They're protecting the judges and the DAs and the...
Oh, Jesus. Okay, so now there's some giant conspiracy.
Prosecutors. They're protecting the probation officers who are going to lie in court and the cops who are going to lie on the stand. If you have an audio recording of it in court and you have a video of it on the street, then you can prove that the cop was lying.
Or if you have a transcript, you can prove the cop was lying. At one point, like if the cop says one thing on the street and another thing on the stand, you can prove that he lied on the street. But that doesn't necessarily mean he's lying on the stand, because remember, cops can lie to you. But just saying that they're always lying to you, I don't know where you're getting that from. If there was some conspiracy between judges and prosecutors and parole officers and the police to deprive citizens of their liberty, i.e. imprison citizens for crimes they didn't commit, then one would assume that public defenders and private defense counsel would point that out. Would be like, hey, there's this thing going on. But they're not. Oh, well, obviously the defense attorneys must be in on it too. Oh, well, that's weird. Are juries in on it as well? Because juries sit in on criminal trials, at least on any criminal trial where the person can get, or where the person gets, 6 months or more, or is it a year? I don't remember. It's more. I don't remember off the top of my head right now. But there's a certain period of incarceration that if you get that much or more, or if you could get that much or more, I think it is. Yeah, if you could get that much or more, you're entitled to a jury. And criminal trials are, generally speaking, open to the public. And so, wouldn't or couldn't news be there to report on it? Wouldn't there be Court of Appeals cases where these things have been alleged and proven? Why can't you cite to any of those? Why do you just have to say this blanket statement of there is this conspiracy without any underlying facts to support it, except for your stupid poster? You haven't really given any good reason why the court should allow it.
And so when you can't record in the courtroom, this is the result of not having transparency in the courtroom.
What are you going to do with that recording? Just out of curiosity, let's say for whatever, because there's a lot of sovereign citizens out there who record their court procedures surreptitiously, and then they post it on YouTube, and everybody laughs and laughs and laughs at the stupid sovereign citizens with their stupid sovereign citizen argument. I'm just seeking some clarifications. I'm ready to plead guilty if you could prove jurisdiction. Are you going to give me a full and fair hearing today? I mean, we just laugh at these people. They record, Chillie. They record their interactions with the judges. And I have yet to see one of them come back with a judge who's actually corrupt and they catch the judge in his corruption. I have yet to see that. Now, of course, the sovereign citizens think that they're catching judges being corrupt. What's his name? Juan Galt posted one today where the sovereign citizen was I think at an arraignment, and the judge didn't have the file. The court didn't have the file. The court was like, "Oh, we can't really proceed today." And the sovereign citizens was like, "Oh, do I get a full and fair hearing today?" And the judge was like, "No, no, you don't get a hearing today." And the sovereign's just like, I just want to be clear that I don't get a full and fair hearing today. The judge was like, "No, you don't get a hearing today." And the sovereign citizen didn't understand. He didn't understand that he's not getting a hearing that day. And he'll get a full and fair trial. and that's all he's guaranteed is a full and fair trial. So I don't know. You're not making any sense to me, Chillie. I'm going to take my video to YouTube because that's going to get me justice. What are you going to do with that recording, Chillie? What are you going to do with it? You going to file your appeal? Why can't you do that with a written transcript? Because you know what the appeals court's going to say? They're going to say, "Send us a written transcript." They're going to say, "Send us the written transcript." They're going to ask for the court reporter's transcript. There's the clerk's record, and then there's the transcript. They're going to ask for both. The clerk's record is all the filings, all the motions and orders and things like that have been filed in the case. And then the court reporter's transcript is going to be the record of what was said orally at argument. And nowhere in there is the appeals court going to ask for the audio-video recording. And if you try to send it to them, they're going to say, "Nah, we can't use this."
Record the cops on the street, but it doesn't matter because if you can't record the court, then the judges are going to cheat you.
What do the judges gain by convicting you or cheating you, as Chillie so articulately puts it? What does the judge gain by that? The judge he gets paid, as whatever his state rate. He doesn't get paid by the conviction. He's not getting kickbacks from the district attorney. What is in it for the judge? Why is the judge going to cheat you? Where is the motive for the judge, Chillie?
If you think that this is Americans are getting a fair deal in court, just look at this prison graph right here.
Well, just because there are more people in prison, that could be a function of a lot of things. That could be a function of a higher population. I don't know if you're aware of this, but the population of the United States continues to grow. It could be a function of more laws being on the books. It could be a function of better policing, catching more criminals. It could be a function of stricter sentencing. A lot of times places like to increase the prison sentences, which means that you can stay in longer, which means prison populations are going to increase. Your little stupid graph on your stupid expensive poster is meaningless.
Just look at it.
Post hoc ergo propter hoc. Just look at it. Just look at it. The numbers are higher. The numbers are higher. Therefore, it must be cameras in courtrooms, except I spent the whole time talking about everything but cameras in courtrooms.
You think people got worse? Or they created legislation and they created it so they could make you a criminal?
Oh, wow. You just undermined your own argument. First, this is because of no cameras in courtrooms. And then you go and make the exact argument, one of the exact arguments I said, where they've made more things crimes. Congratulations, Chillie. You have cracked the case. It's nothing to do with cameras in the courtroom.
They created these things to make you a criminal.
Yeah. Passing laws criminalizing acts makes more people criminals. Yeah, that's the way it works.
I mean, and then when you read the police commissions, including the 1929 Seabury Commission, the 1931 Wickersham Commission, the 1972 Knapp Commission.
Read these things because I put them onto my little poster and I need to sell my poster.
The 1994 Mullen Commission, you find out that cops are scum.
Well, yeah, cops, not all. I mean, but in any sample of humans, there's always going to be those people that are scum and those people that aren't. And, Unfortunately, the law enforcement profession attracts a certain kind of person, or a few certain kinds of people, and some of those like to abuse power. They want to be cops to have power, and that makes them a bad cop because they like power. So, yeah, but I don't know that you have to read these commissions. I mean, I've been a lawyer now, for a family law attorney now for almost a full year, and I've never had to read any commissions. And I've had a few criminal cases, still never read any commissions.
That William Bratton and Chief of Police Michael Moore in Los Angeles, these guys are scum. They're scum. They're bad.
They're scum, so I put them on my poster, by my poster, so you can have the scum.
Bad people. They're not good people. And so when you have all of these bills created to make us a criminal, the 1960...
Yeah, if you have all these statutes that criminalize things,
Omnibus crime bill. Everything's a crime, and look what happened.
Omnibus crime bill. Everything is a crime. Holy shit, that's the most retarded thing I've ever heard. Not everything is a crime, Chillie. Not everything is a crime.
Happens to our prison system. Look what happens.
So before 1968, what? Nothing was a crime?
It's insane. If you don't know Wilson versus...
And again, you just... So now the reason why we have all these criminals is now the 1968 Omnibus Crime Bill. So why, again, do we need cameras in the courtroom?
Arkansas, why they can raid your home and kill you in your home? It's because of the 1995 case of Wilson versus Arkansas. And this...
They could raid your home and kill you in your home because of... Oh, Jesus Christ. That is the stupidest thing ever.
1985 case where Harry Blackman is going to reverse himself. He's going to reverse himself is what he's going to do. And he's going to say you can't shoot people when they run away unless it's in the name of officer safety.
No.
You have to know all these cases. You have to know all of them.
No.
You have to know.
No, it's not necessarily for officer safety. It's if you think that they're going, if you have probable cause to suspect they're going to be a threat. I'm guessing it's something like that. But it's they have to be a threat. They, like, if it's somebody running away with a gun, you could shoot them in the back because they could hurt someone else. They might not be a threat to you, but if they run away with a gun, they might be going to shoot someone else. You know, they're a violent criminal or something like that.
That Matt versus Ohio is essentially going to be overruled with the 63 case of Kerr versus California.
Holy shit. No, it's not. No, it's not. Kerr versus California is search incident to lawful arrest. Matt versus Ohio was where the court decided that the Fourth Amendment applied to the states and that the exclusionary rule would apply if a state searched, if the state conducted a search that was prohibited by the Fourth Amendment. So in Matt versus Ohio, they were looking for, I think, porn or something like that. Porn was illegal back then. And the police did not have a search warrant, or they had something that they said was a search warrant, but it wasn't a search warrant. Essentially, there's no evidence that there actually was a search warrant, other than the police saying a certain thing was a search warrant, but never letting anybody read it, if I remember correctly. So they searched this gal's house, and they ended up finding some porn somewhere. But they searched her entire house, right? And so they charged her with possessing pornography. And the Supreme Court of the United States said, you can't just search people without a search warrant. You got to have a search warrant to search a house. And, you know, that's Fourth Amendment. Fourth Amendment applies to the states. Kerr versus California. California already had, before Matt versus Ohio, California recognized search warrant requirements pursuant to the Fourth Amendment, the 14th Amendment, and Article 1, Section, oh, Jesus, I'm going to get this wrong, Section 19? I'm going to guess that. Anyway, California, since like 1955, People versus something that starts with a C. I don't remember the name of it. California Supreme Court case. California already had warrant requirements. So that wasn't the issue. They weren't dealing with Matt versus Ohio because state law, California state law, even before MAP, already said the Fourth Amendment applies to the 14th Amendment. Plus, California's own constitution applies. So you got to have a warrant. But what Kerr was the cops went to arrest somebody. They went to somebody's house. They had probable cause for the arrest because I think it was like a drug buy. They had already conducted the drug buy. But they didn't arrest him when they did the buy. Hold on, let me think. It was something like they arranged for a drug buy through like Guy A, and Guy A took them to basically a place to meet up with Guy B. Guy B gave Guy A the drugs, and Guy A came back and brought the drugs to the cops. And the cops tested it and found out it was in fact the drugs. I don't remember what drug. And then like, okay, we want to arrest Guy B. So they did some research or something. I don't remember exactly what they did, but they figured out where Guy B lived. And so they went to like the apartment manager or whatever, and they got a key, and they entered to arrest him, right? And California said, "Oh, it's so they go in there, they go in to arrest him, and they find drugs. They find drugs, and they charge the wife as well as him. And I think the wife is the one who appealed." And if I remember correctly, the Supreme Court was like, no, it's so they had probable cause for the arrest. And so when they were making the arrest, they could see this stuff there in sight, and it was a search incident to a lawful arrest. They're like, hey, we're arresting you. We're here to arrest you. And, oh, is that drugs? And it was drugs. And it was sitting out like on the counter or something like that, or on a table. And they knew it was drugs, and they could tell it was drugs because it looked like drugs. I'm going to say marijuana. Or was it cocaine? Or was it heroin? Anyway, they're like, that's drugs. And so they arrested, they had probable cause already for the arrest of the dude to go in there. They see those drugs in there, and now they have probable cause to arrest wife because, well, they're allowed to be there to make the arrest, and it's a search incident to a lawful arrest, and she's there in possession. So boom, bada boom, bada bing. So it's two different things. It's MAP versus Ohio says you have to have a warrant to search. Kerr v. California was a search incident to a lawful arrest.
You have to know what the correlation is between MAP versus Ohio and Kerr versus California. You have to know these things.
Yeah, and you don't. And you've been studying Constitution for 20 years.
All right. This is our prison system today. You think you're getting a fair shake in court? You think you're getting...
If you're not getting a fair shake in court, I don't even know what you mean by a fair shake in court. If you think you've had ineffective assistance of counsel, you can make an appeal. If you think that the court, if you tried to suppress evidence and you did not suppress evidence, and the court said, no, we're not going to suppress that evidence, you can file an appeal. If you made a statement under duress or coercion and you made an admission, you can file an appeal, and you try to get it suppressed as a Miranda violation, you can file an appeal, right?
Getting a fair shake? Does that look like you're getting a fair shake in court to you?
It just saying that more people are in jail doesn't mean that the court isn't impartial, and doesn't mean it's not rule of law.
Is that what that looks like? It doesn't look like that to me. All right, guys, I hope you have a great day. You can get this poster on my website, Delete Laws. I have a hard copy available. You can get the downloadable one and go print it out at Kinko's or Office Max, and it's fairly inexpensive.
$25 is not fairly inexpensive. Anyway, that's all just him signing off. Yeah, it's a completely worthless poster. I just want to put out my opinion on whether or not we should have cameras in courtroom. Absolutely, we should. I am strongly in favor of courts recording with in-court cameras, audio, video recording. I don't think it should be like individuals doing their own thing running around trying to get the best audio or the best shot, because that can be disruptive. But I think the court should, like, put up on YouTube or whatever, court proceedings. You see, actually, a lot of courts have taken to that, especially with COVID going on. You've seen there's a lot of courts out there that are now televising their proceedings, or putting up on YouTube their proceedings. And I think that's a good thing. So I'm in favor of that. I'm not in favor of individuals trying to record, because that can just be disruptive. It's just disruptive. I'm sorry. You might think that your desire to record is greater than my desire not to be disrupted by someone trying to get the best shot. But I'm entitled to my opinion, and that's my opinion. So anyways, thanks for watching. Chillie has no idea what he's talking about, and he's all over the place, but he really, really, really wants to sell you this poster for anywhere between $25 and $140. Thanks for watching. Have a great night.